Hello, and welcome back to Management 3504. This is Dr. Maggie Vivoda, and of course, we're studying human resource management. Today, we're going to talk about complying with workplace justice laws. As you know, in the workplace, there have been several pieces of legislation that have gone through primarily to protect either the public or the employee. We're just going to talk a little bit about a couple of them in this particular PowerPoint presentation. Please keep in mind that you want to make sure that you not only watch and listen to this PowerPoint presentation, but you augment it with reading your textbook. Linking workplace justice to competitive advantage. Workplace justice laws deal with the fairness of organizational practices that dictate the day-to-day treatment of employees. Competitive advantage can come from reducing litigation costs, favorably affecting employee attitudes and behaviors, promoting a favorable company image. As we all know, litigation can be quite costly. We do live in a litigious society where lawsuits are very common. If you take a look at this particular form, it's a summary of EEOC guidelines on sexual harassment. That's what we're going to be talking about today. What is sexually harassing behavior? Welcome sexual advances, requests for sexual favors, and other verbal or physical contact of a sexual nature. But when does sexual harassment actually cross over into becoming unlawful? 1. Submission to such contact is made either explicitly or implicitly a term or condition of an individual's employment. 2. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions. 3. Such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. 4. An employee is denied a job opportunity because it has been granted to someone who has submitted to the employer's advances. When is an employer held responsible for acts of sexual harassment committed by others? 1. The employer is responsible for the acts of its agents and supervisory employees with respect to sexual harassment, regardless of whether the employer knows or should have known of the occurrence. 2. The employer is responsible for the acts of sexual harassment committed by coworkers if the employer knows or should have known of the contact, unless it could show that it took immediate and unless it can show that they took immediate and appropriate action. 3. An employer is responsible for the acts of non-employees with respect to sexual harassment of employees in the workplace, if it knows or should have known of the conduct, if it fails to take immediate and appropriate action, and has the ability to control the contact of non-employees. What's very important to know about sexual harassment is what you see on the left side of the page. Not only is there intent, there is actually here a denial of a person. Perhaps an individual is promised a promotion in return for sexual favors, but the person rejects that and then later is denied the promotion. That is a clearly cut case of sexual harassment. What are problems that are caused by sexual harassment? Well, there's an increase in employee turnover, usually due to the fact that employees are uncomfortable with the person that approached them. There's an increase in absenteeism. There's a decrease in employee morale. There's a lack of effective teamwork, particularly if more than one individual knows about the sexual harassment. Poor productivity. There is employee stress and or psychological problems. And unfortunately, there's costly compensation damages as well. There are two forms actually Well, they say 3 forms of sexual harassment. 2 are actually the most common, the ones that you would read. One would be quid pro quo, and that refers to a situation in which an employee or applicant must provide sexual favors in order to be hired, promoted, granted a pay raise, or allowed to keep a job. Employees are subjected to unwelcome, intimidating working conditions, that's hostile environment, and reverse sexual harassment occurs when a person is denied employment opportunity that was given to someone who complied with requests for sexual favors. Quid pro quo is actually related more to being denied a promotion. Hostile work environment would be like emails, crude jokes, that sort of thing. What are steps an employer should take for dealing with sexual harassment? Well, the employer should establish a written sexual harassment policy, provide supervisory training that focuses on the legal definition of sexual harassment, establish investigative guidelines that maintain employee confidentiality, establish a committee composed of both men and women to investigate sexual harassment claims, establish a means for detecting unreported cases of sexual harassment within the company. EEOC guidelines for developing a policy on sexual harassment. 1. Define sexual harassment and stress that such conduct will not be tolerated. 2. Establish a complaint procedure. 3. Establish a time frame for investigations. Excuse me. 4. Establish appropriate penalties. 5. Ensure confidentiality. 6. Provide protection against retaliation. Now we're going to talk a little bit about the Pregnancy Discrimination Act. Pregnancy discrimination is a form of sexual discrimination and therefore is considered illegal. Firms may not discriminate against employees on the basis of pregnancy, childbirth, or related medical conditions. Employees who are unable to perform their jobs adequately because of a pregnancy-related condition must be treated similar to employees who are temporarily disabled for other reasons. Provisions of FMLA. You may be familiar with this. This is an act that was created in 1993. And basically the purpose of the act is to allow most employees to take up to 12 weeks of unpaid leave each year for the following reasons: childbirth, or to care for a child in the first 12 months after childbirth, adoption or foster care within the first 12 months of placement, care for a seriously ill spouse, child, or parent, care for the employee's own health problem if it renders the individual incapable of performing his or her own job. You can see here also the coverage, obligations, and scheduling leave. Once again, the emphasis here is that it's 12 weeks of unpaid leave each year for the following reasons. Here we have another an act that was developed a form of legislation, provisions of the Older Works Benefit Protection Act. The waiver document is signed by the employee and it must be clearly written, understood by the ordinary person, inform employees of their rights, which is ADEANOWBPA, states that employees are not waiving their rights to claims occurring after the waiver is signed, provides the worker with something of value for taking early retirement beyond the employee's normal retirement, gives the employee 21 days to consider whether to sign the waiver, 45 days in case of a layoff, and allows employees to revoke their decisions for up to 7 days after they sign the waiver. Employees clearly have privacy rights. 4 privacy-related practices that are legally regulated: information collection and use, search, surveillance and monitoring, and enactment of workplace rules. I always emphasize the fact that when you're on Facebook, when you're on a computer, when you're on the internet, when you're at work on the property of your employer has the right to look at anything you write or receive. In addition, your employer has the right to surveil the property, such as cameras, etc., in the actual workplace. Now, bottom line is, how can the Human Resource Department actually help with all of this? HR professionals implement discipline and discharge policies by conveying the organization's code of conduct to the employees and through training programs and employee handbooks. They also develop a conflict resolution mechanism with an open door policy, peer review panels, mediation, arbitration, and use of an ombudsman. That's a liaison. Assist managers with workplace justice related issues. So, as you can see, human resource managers have a very important role within the workplace. And although we've mentioned a few different pieces of legislation that have gone through, you can see there are many, the workplace is very complex and things can happen. So human resource management team has a very important role in the workplace. Well, I do hope you enjoyed the PowerPoint presentation, and I also hope that you will enhance this PowerPoint presentation by reading your text. Enjoy, thank you, and have a good day.